Hello everybody, my name is Filipa and I am the founder of Route501 Advocacy and Support Limited. We've been established to help support and advocate for people who are currently and have been held in Australian immigration detention centres. This video is about releasing information for everyone to have transparency and communication about our upcoming class action lawsuit against the Australian government. So first question, what is a class action? Well, a class action is where a wrongdoing has affected more than one person. A group claim can sometimes be made on behalf of everybody affected. This is known as a class action. This allows multiple individual claims to be brought together in a single lawsuit. The class action may be advantageous for affected persons because it allows them to pool resources and pursue claims that they otherwise would not be able to pursue on their own. In this case, if successful, the court can fairly divide the compensation amount between the group. Who will be eligible for this class action lawsuit? Everyone who has been or is currently detained under Section 116 of the Migration Act 1958, which allows for cancellation of visas under general grounds such as a breach of visa conditions, change of circumstances, and provision of false information. Everyone who has been or currently detained or deported from Australia under Section 501 of the Migration Act, which states that anyone who is sentenced to more than 1 year imprisonment cumulatively is subject to deportation. We'd also like to note here that anyone who's been detained on the offshore detention facility in Nauru under Section 116 and Section 501 of the Migration Act will also be eligible, though the facility is run by a Naurunian government commercial entity. Our position is that the nature of detention, indefinite detention, poor conditions, etc., is problematic regardless of the reason, and that separately, Section 501 is a problematic reason for detention or deportation. Will non-New Zealanders be eligible for the class action? The answer is yes. The class action will be open to anyone deported from Australia or detained in Australia under Section 501 of the Migration Act, and everyone detained under Section 116 of the Migration Act. No matter what nationality, guys, this is about us all doing it together. The class action is forming in New Zealand because that is where I am based, and also where our legal team are structured from. But we have had people coming on board from across the globe, and we believe that we can represent everybody fairly and correctly. Okay, so why is the class action limited to actions after 2014? Well, we have to limit the scope for the class action for two reasons. First, policy and legislative changes in 2014 made the deportation regime more draconic. Secondly, we are mindful of practical considerations. An overly optimistic scope at this stage may decrease our chances of success. So let's keep it with an achievement that we believe that we can win. So why are we taking a class action? What are we hoping is the outcome? And what are we seeking from this class action? Well, first of all, we do not believe in indefinite detention. We're seeking a legal finding that indefinite detention is unlawful. Secondly, transparency and accountability of the Commonwealth of Australia and its agents. Thirdly, possible closure of offshore facilities and the detention facility on Christmas Island. Number 4, the detainees realise that we may not receive financial compensation. And if we do, compensation will be divided evenly between those who have registered as claimants for the class action only. Lastly, a comprehensive legal opinion is the first step, followed by a strategic litigation, public interest litigation plan. When will this class action commence? When are we actually going to start? Well, the first step is finalising the legal opinion. Following that, the legal landscape and the roadmap will be developed. Also, currently, I am in the process of formatting a web page with Massey University, who have volunteered their time and resources to help us with this situation. The website will be interactive and will have all information regarding the class action, registration, how we're seeking funds, and also transparency on how people will be able to communicate and interact with us. So what's the process? What are we going to do and how are we going to do it? What process are we going to use for taking the class action against the Australian government for its treatment of people deemed 501s? The very first step, to finalise the legal opinion and define the legal issues, to come up with what our strengths are and how we can go forward in the most strategic, strongest way. Secondly, the requirements for a class action in Australia are: 1. 7 or more persons have claims against the same person, and the claims of all the persons are in respect of or arise out of the same, similar, or related circumstances. And 3. The claims of all those persons give rise to a substantial common issue of law or fact. An application will be made setting out the group to whom the proceeding relates to, the legal issues involved, and the relief sought. So, the most asked question of them all is, how can people join the class action? Well, class actions in Australia work in an opt-out model. This means that all potential claimants become members of the action, whether they intended to participate or not. These members are bound by the judgment of the court or settlement unless they opt out. We ask people who would like to be registered as claimants, please contact myself, Filipa, directly. Currently, you can contact me via Route501 Facebook Messenger, or as I stated earlier, the webpage will be available soon, which have direct links of contact and registration. So, who exactly are we taking to court? Well, at this stage, our view is that the claims will likely be against the Minister for Home Affairs, the Minister for Immigration, Citizenship, Migrant Services and Multicultural Affairs, and/or the Commonwealth of Australia. We are also exploring the possibility of an action against the New Zealand Government for its role on imposing post-release conditions on deportees who have already served the entirety of their sentence. This may change as legal opinion develops further. In which court will these proceedings be taken? Well, we're likely to be taking the proceedings to the Federal Court of Australia, or whichever court we feel applicable. So, under what laws or statutes will we be challenging the policy? We are still in the process of developing the legal opinion. There are several options available to us under both the Australian Migration Act and international law. So how are we going to raise the money to do this? How are we going to raise the funds for a class action? Well, we're seeking funding from interested NGOs, non-government organisations across the globe. We will also seek that registered claimants contribute $500 each as a small token towards the cost. Route501 Advocacy and Support Limited have also established pathways to donate through credible merchants, vendors, such as GoFundMe and PayPal. Our donation page will be available on the website as soon as that becomes available once completion of it. How many people will be part of the class action, and do they have to buy in financially? Well, we've received over 2,000 inquiries so far from people who would like to register and join our class action lawsuit. Because class actions in Australia operate on an opt-out basis, the total number of plaintiffs may be significantly higher than that. Each claimant who registers will be asked to contribute $500 as a small token to go towards their legal costs. Provisions are available for payment options to suit the claimants. Our goal is, guys, we need to raise $100,000 to get this action moving. So how are we going to do it? What strategies are we going to develop? This is a complex and important piece of legal history. There are many moving parts, and no legal strategy by itself will be effective. To that end, a number of aligned multidisciplinary initiatives are planned: legal research, litigation, and general advocacy, non-legal specialists, cultural, medical, political and government agencies. We need media and social influencers. We need NGO and stakeholders. We need funding from some NGOs and contributions being sought from detainees and donations from global community support. Are other countries doing similar things? The United States has several immigration detention centres, ICE facilities, that have faced similar criticism. Immigration detention facilities are used by many other countries. However, what sets the Australian model apart is the scale of this practice, the indefinite detention, and the conditions of these facilities. We're 501 deportees being held and detained. Well, Australia has 4 offshore detention centres, 3 facilities in Manus, and 1 facility in Nauru. Onshore, they have a facility in Christmas Island, 1 facility in Northern Territory, 2 facilities in Western Australia, and 2 facilities in New South Wales. It's a pretty sad question when we ask ourselves, why should we care about other human beings? But here's a list that we've come up with. Anyone who's been sentenced to more than 1 year imprisonment cumulatively is subject to deportation. Hardly the worst of the worst as described by the Australian media. Many 501s have relatively minor convictions. Many 501s also have strong, and in some cases only, family connections with Australian citizens, living there most of their life. They have no connections or resources outside of Australia. Whilst detained in Australian immigration detention centres, detainees are subject to abhorrent treatment, to brutality, to trauma. Medical treatment has at times been denied to those in need and is often given at a substandard manner whilst in detention. The trauma that is brought on whilst in Australian immigration detention centres is worsened by the displacement that occurs through removal from Australia from deportation, and it is not currently being addressed or acknowledged by the Australian government.